So we shall be passing through corporate and commercial orals topics, and the module one will deal with business association. So this module deals with establishment of various businesses and structures that enable clients effectively run their businesses. So in here we looked at the different types of business entities that include one partnerships, sole proprietorship, limited liability partnership, as well as general partnerships. So there are very wide range of businesses that can be set up in Uganda. Legal practitioners are oftentimes called upon to advise on formation for the and management of their businesses. It's therefore important that lawyers are equipped with skills to enable, facilitate the setup and running of these businesses. So workshop one, the aims of these workshops are to one, the aim of this model is to one, develop the ability to advise on business setup and management. So basically here you must be alive to the fact of how do you establish a partnership, how do you establish a sole proprietorship, and also how do you establish companies. So basically we looked at partnership. You basically don't have to register the partnership name if you're using your own surnames. But where you have opted for a different name, you have to proceed and register the partnership name under the Business Name Registrations Act. So for you to have a partnership one, you need what we call a partnership deed. And if you have used a generic name, you have to proceed and also register that under the Business Name Registrations Act. So when I said also self-proprietorship, they do not need any form of they do not need any special form of registration. But also if you have given a name to your business, you must also proceed and register it under the Business Name Registrations Act. Develop ability to set up businesses. So we shall look at basically how do you set up a company by filling those forms, and now it's always online. You have to fill all the application for registering the company. You have to also fill in the nominal, the form on nominal share capital. You have to fill in the memorandum and articles of association, also the beneficial owners, as well as the notes of directors. So those are some of the forms you have to fill in when you're going to register a company. Then we looked at develop the ability to structure the management of businesses, recognize and resolve with ESCO issues arising in setup and management of business entries. So running outcomes, by the end of this module, we should be able to explain features of various business associations. So basically here I have to know what are the features of a partnership, and we know that in the partnership, the partners enjoy unlimited liability. And also see the case of Gatete versus Gatete, where the court is saying that if you're going to serve the partners of the firm, you must serve to all the partners. Then also looked at a sole proprietorship. The owner of the business enjoys the profits and losses of the business, and after his death, the business goes to his family. Then also looked at partnerships, general partnerships, and say the general partnership. In here, the liability of the person is unlimited. All the liability of the partners in the general partnership is unlimited. We also looked at the limited liability partnership, and we said in limited liability partnership, we have one partner whose liability is limited. This could be a minor or any other partner. We also have professional partnerships, and these include accountants and lawyers, and they can go up to 50 members. We also looked at different types of companies, private companies, and see that in private companies the members are restricted up to 100, and also there is an restriction of the transfer of shares. Then we also looked at NGOs or non-government organizations, and how basically can you apply and get an NGO. But basically what we looked at is you must first incorporate a company limited by guarantee, and you proceed to have a constitution of the NGO. Then you apply to the ministry, you attach a recommendation letter from the line ministry, and then if they are satisfied, they will give you what we call a certificate of incorporation of that NGO. Then also look at trusts. And of course, we see trust under the case of need versus need, that there must be certainty of object, certainty of intention, and certainty of subject matter. So for you to incorporate a trust, you must apply to the line ministry, and after applying to the line ministry, if you have other conditions, the ministry will give you what we call a license for you to we shall incorporate a trust for you to proceed and have a trust which could be on land or maybe any other property. We also looked at single member companies, and we said for single member companies there must be a nominal director and an alternative director. So basically, when we talk about a single member company, we meant a company which has only one director. But for you to have a single member company, you must have a nominal director. In case you have died, that nominal director can help in transferring the business to your family. And in the absence of the nominal director, you always have an alternative nominee director. Establish. We also looked at private and public companies. Of course, Section 2 of the Companies Act defines a company as any business entity which is registered under this act. And we said for public companies, one, there is free transferability of shares. Secondly, they can also invite the public to buy from their companies, among others. But what you have to understand is public companies, it's more of it has public shareholders. So the difference between public companies and private is private company cannot invite the public to buy its shares, whereas a public company can invite the public to buy its shares. Establish an appropriate business association for your clients. So you have to look at your needs of your client and be in position to advise the most appropriate business entity. Draft documents necessary for the establishment of a business association. We drafted a partnership deed for partnerships, and one of the key clauses we had, one was termination, duties of the partners, contribution of the partners. We also looked at notices, dissolution of the partnership, partnership property, among others. Then for the companies, of course now has since been online, but you have to fill in the application form for registration of the company, the nominal share capital form, the beneficial owners form, the memorandum and articles of association, as well as the notice of the location of the company. So those are some of the documents we had to draft to incorporate a company. So organize and deal with ESCO issues relating to business establishment. So in ESCO issues, we are dealing with one, not overcharging your clients, doing proper due diligence, and also doing work within the reasonable time, but also avoiding conflict of interest. Then we looked at workshop 2. The aims of the workshop are to develop your ability to hold various company meetings. Remember, we have a statutory general meeting which is always conducted within 3 months after incorporation of the business. We also looked at an extraordinary general meeting which can be called in case there is an urgent matter, and we also looked at what we called annual general meeting, which is conducted every year. So for you to call a meeting, you must first serve 21 days notice, and also the process of rectifying that notice, if it has been served shorter, by basically getting consent or maybe a resolution from the people who were supposed to attend and vote on that specific meeting. So we also have to develop the identify and deal with shareholder rights, and basically we have the case of Matthew Kakire versus Incafex, which discussed the shareholder rights. Because Matthew Incafex had sued the director of Matthew Kakire had sued the director of Incafex, alleging that he had been stopped from accessing company premises. So he alleged that his rights were being violated as a shareholder. The company sued its director replied and saying that first and foremost, you are not a shareholder because the shares you hold are in trust of the South African company. But of course, the court proceeded to define who is a member, shareholder, and also a subscriber. And the court stated that a member is the person who is registered on the articles and memorandum before the company is incorporated. Then after the company has been incorporated, a member becomes a subscriber, and after the subscriber has been granted shares, he or she becomes a shareholder. So you have to understand that we have looked at rights of the aggrieved shareholders in the in the mutual courts case, in Musa, I think Musa Courts apartment, where also the shareholder challenges that he was also not allowed to enter company property, and of course the court stated that an aggrieved shareholder can proceed under section 243 and 244 to petition a registrar or a petition to court, so as the rights of the shareholder can be resolved by court. So the rights of the shareholders include: one, a right to access a share certificate, a right to profit, a right to participation in the management of the meeting, a right to attend the meeting, among others. Then also looked at develop your capacity to convert a company from a private company to a public company. So basically this is provided for, I think, by section 22 or 24 of the Companies Act. Basically what you have to do is you must first pass a special resolution, and if you have passed a special resolution, it's always accompanied by statement of auditors. It's also accompanied by financial accounts, also opinion from lawyers. Then after that, a director has to swear a statutory declaration that all the requirements have been achieved. So if you have a special resolution and also an alteration of the articles and a memorandum of association, a statement from auditors, then a statutory declaration, you can proceed and apply the registrar, and then if the registrar is contented, he will convert the company and issue a certificate of incorporation of a public company. ESCO issues, of course, you must make sure you do proper due diligence, you adhere to the timelines, you file all the necessary documents to make sure that you are within the requirements of the law. So we looked at some of topics or areas. We looked at establishment of a business entity or vehicles, sole proprietorship. We say sole proprietorship is a business which is owned by one person, and he enjoys all the profits and losses of the businesses. Procedure of creation, you don't need any formalities to create a sole proprietorship, but if you have opted for a business name, you must proceed and register it under the Business Names Act. Procedure of business name registration documents for business name registration. Sample questions. Here we look at what are the risks for sole proprietorship who fails to distinguish personal from balance assets in Uganda. So basically these were the sample questions for oral questions, but let me see whether this is basically as for corporate and commercial practice continuation, we looked at the list of topics covered. 1, business setup and management, identification of various business associations to include sole proprietorship, to include companies, to include joint ventures, as well as sole proprietorship. So basically when we talk about a joint venture, is where one business entity comes with another to do a specific project for a given period of time. Procedure for setting up businesses. We look at the different procedures. Basically, how do you set up a company, and how do you set up a partnership, as well as how do you set up a sole proprietorship. Then establishment of business management structures. We looked at how do you establish a business management structure. So if it's a company, you have to basically call a statutory meeting, because this statutory meeting is the one which helps you to establish business management structures. So management of the businesses, we can say that a company is managed by its directors, and under section 194, we see the duties of the directors is to act in the best interest of the partner of the company. So basically, in making their decisions, the directors must ensure that the interests of the company are being met and avoiding conflict of interest. So as partnerships are concerned, the partners are the ones responsible for the running of the partnership. So we always have an active partner who basically plays the role of running a partnership. And remember, we have the case of Komakech. Dr. Stephen versus David Komakech. These people had agreed to do what we call a tax business, but then later this person alleged that there was no partnership deed, and even the other person was not involved in the running a tax business, therefore there was no partnership. But the court stated that of course there can be an active and a dormant partner in a partnership, and also there is no need to register a partnership for there to be a valid partnership. We looked at, of course, statutory compliances. Statutory compliances include, of course, filing annual returns, filing a statutory report, filing allotment of shares in case shares has been allocated, and also filing minutes of the meeting, among others. Then we looked at recognize and deal with issues relating to these ones, and business covered includes sole proprietorship, partnership companies, private and publics, and also NGOs. We also looked at how do you get an NGO by basically applying to you first incorporate a company limited by guarantee. Then after that, you have to proceed and get recommendation from the line ministry, get recommendation from the local council area you are going to operate, and then proceed to apply to the ministry so as you can be given a license for your NGO. Management of the businesses, we refer to management of partnerships. Basically, I will say that partnership are governed through how you agreed in the partnership deed, but we always have whom we call active partners. Board meetings, a board is how basically a company is run through board meetings, ordinary resolutions, and special resolutions. Basically, that's how a company is run. General meetings, also general meetings including extraordinary general meeting, annual general meeting conducted each year, and also statutory meeting, which is always conducted between 3 years, which is always conducted after 3 months after the company has been incorporated. Then we look at voting by poll. Voting by poll basically means that each person has one vote. So irrespective of the shares you have, each person will be entitled to one vote. That's what we call voting by poll. Then voting by show of hands is where the people are present at the meeting votes by showing up their hands. Then also we have proxy, where they allow proxy to attend. That means you can assign another person to attend on your behalf on that meeting. We looked at resolutions. One ordinary resolution passed from a general meeting, but here ordinary resolution, you just need a simple majority of 51% and above. We have a special resolution. In a special resolution, you need at least more than 75% of the majority shareholders. Then also we looked at board resolution, which are passed from the board. Mandatory company filings, of course, you must file a statutory report. You must file a notice of situation of office, appointment of directors and beneficial owners. Those are some of the mandatory filings of the company. Shareholder disputes. We also looked at shareholder rights, and remember, in the case of Foster versus Haboto, the proper plaintiff is always the company itself, but where the rights of the shareholders are grieved, then the shareholder can bring up what we call a suit to a petition to prepare to protect his or her rights. And we can see under section 243 and 244 of the Companies Act, you can petition the registrar. Also, you can petition the court. Then also that partnership property. My partnership property is always managed according to the partnership deed, but the Partnership Act states that once you bought property with the intention of it becoming partnership property, then of course it will have to become partnership property. Then also looked at winding up of partnerships and how can you dissolve partnerships. So partnership can be dissolved by court where there is an illegality, where one partner has served a notice or terminate the partnership, and also partnership can be dissolved in instances where it was a fixed period of time, and once of the expiry of that time, partnership can as well be dissolved. Retirement from partnerships, you retire from partnership basically by serving a notice to other partners. So once you have served a notice to other partners, then you have retired from that partnership. But what you have to understand is about the liability, because you will be liable for the debts of the partnership after the date when you retired. So we also looked at corporate financing, models of corporate financing. So basically here we looked at ways of how a company can raise capital. One is giving out equity. Equity is about when you give a third person shares in your business, then you have given him equity. We also looked at call-on shares. Call-on shares arises where you have a shareholder who has not fully paid up his or her shares. So once you have a shareholder who has not fully paid up his or her shares, you can basically pass a board resolution and issue a call on that shareholder to pay up the balance of all the shareholders. And if the person doesn't pay the call, that's where we have forfeiture of those shares. These shares can continuously be forfeited if the person did not respond to that call and issued back to the public. Increase of shares. This can arise when a company increases its shares. For example, if you initially had 1,000 shares, now you can increase them to 2,000. And then after increasing the shares, you have to file the increase of share capital. And then these shares can also be issued to the public. Issuance of shares at a premium. This one is provided for also by the Companies Act, I think sections 66 or 64 therein, that you can issue shares at a higher price than the price which you formerly issued these shares to the public. So if you are issuing shares at 1 million, you can now issue them at 2 million, but there must be a board resolution for you to issue shares at a premium. We also looked at preferential shares. Preferential shares, I think, are under section 66, then premium under section 64. Preferential shares are the ones which are given special treatment, and this could be maybe in payment of dividend, that you have a fixed dividend that are always paid. But for you to issue preferential shares, you need what we call an ordinary resolution. But for you to issue redeemable preferential shares, you need a special resolution. So redeemable preferential shares means that they have a specific period of time in which they will be bought back. So we looked at debt and off the market, debt on and off the market. Basically here we are looking at how do you basically get debt. How does a company raise or get money by borrowing? Procedure of corporate finance. Basically how to pass a board resolution for you to go for raising capital. So we also looked at perfection of securities, and securities can be perfected by registration. You must proceed and register these securities for you to be able to benefit. For document relevance to corporate financing, including raising capital, internally, stock exchange loans, venture capital, and mezzanine loans, we basically looked at different types of raising capital internally and externally. So when we looked at raising capital, one, we looked at venture capital, and venture capital, these basically target startup companies, and also mezzanine loans. It's a hybrid of this of both debt and equity. And then we also looked at equity financing, where funders target companies which are mature but are not yet public traded. We looked at forms of structuring venture capital agreements. Include one, safe or simple agreements for equity, and also convertible notes. Convertible notes are ways of structuring venture capital, but these ones are always upon happening a certain event. For example, the company, when there is taking the company into IPO, maybe to public, then the initial loan, it can be converted into equity. So basically, in convertible notes, the company gives you $10 million, and upon a subsequent round of financing, because they are going to say that we're going to give you $4 million upon each quarter, then that means on the next round of financing, the loan will be turned into equity. The first loan converts into equity. So safes, unlike convertible notes, do not attract any interest, neither do they have a repayment period. So that's basically how we looked at external ways of raising capital, to include venture capital, private equity, as well as mezzanine loans. We also looked at public procurement and disposal of public assets, procurement and disposal, principles of public procurement and disposal of public assets, procurement and disposal of circles. So basically, when we talk about procurement, we mean how does a company procure its services or maybe its goods. So first and foremost, there is always bidding. Then from there, first and foremost, the process begins with the contracts committee. Then after contracts committee proving that there are funds, basically what happens is they issue bids in Gazette. Then the people who are interested can put in bids, and after that there is what we call opening of the bids, selecting the best evaluated bidder. Then after that, up to the point of awarding a contract. But if you have bidded anything from the government, you basically know how basically that works, and that's the process. So we have to explain in case of procurement. So basically, procure first and foremost, you begin from the department unit. The department unit has to come up with its needs. For example, if they want to buy a car, then they write to the accounting officer. The accounting officer has to confirm the existence of the funds. Then after the accounting officers confirm the existence of the funds, they proceed to do what we call issuing a notice in the Gazette, attracting the most possible bidders. So if these people are interested, they make bids. Then we have what we call opening of the bids. Then after opening of the bids, they select what we call the best evaluated bidder. So procurement and disposal cycles, then dispute resolution mechanisms, and administrative review by accounting officer, review by the tribunal, appeals to the High Court, and drafting relevant documents. So basically that's the procurement process. So the disposal process, basically we are looking at if you have a car which is old, how does the company dispose it off? Because also there has to be a procedure the company has to follow for us to dispose of that specific property. Then also look at intellectual property. Basically here we look at trade secrets, identification of trade secrets, protection of trade secrets. So basically when we talk about trade secrets, for example, when we talk about things like Coca-Cola, and basically how does it mix its sodas, those are becomes trade secrets. So the intellectual properties act basically looks at the way how do we protect those secrets because we don't need the market to access basically how we are doing our work. So this one is governed by the Trademarks Act, as well as the Copyrights and Neighborings Acts, which basically deals with how we go about this. So trademarks, identification of a trademark, registration of a trademark. So a trademark basically has it's a sign or mark which distinguishes the products of a business from the other business. If you look at section 1 of the Trademarks Act, registration of the trademark, so we can see that for us to have a trademark, it must be registered under the Trademarks Act. So for you to register a trademark, you have to apply to the registrar, and then after applying to the registrar has to give you feedback as whether that trademark has already been registered or maybe not. So if the registrar writes to you and says it's available, you proceed to apply in a specified form asking that you be registered as a trademark. Then after that, the registrar issues a notice, and if there is no objection, the registrar proceeds to give you what we call a trademark for that very specific product. We start rights that accrue from trademark protection, and basically also if there is anyone who wants to object to that trademark, he can lodge in a notice of objection, basically reject from registering that trademark. Rights that accrue from trademark protection, of course, once you have registered a trademark, that means there is no any other person who can register that trademark, because now it becomes your intellectual property. For example, if you have looked at signs owned by Benzes, BMW, Toyota, they all have their own trademark. So basically it means that you cannot come from here and you register a trademark for Benz, because that would be infringement of that trademark. Then also looked at enforcement of rights, infringement and remedies. We looked at how do you enforce your rights, for example, by temporary injunction, by an Antonio order, seizure. I also looked at damages and costs as one of the remedies which are available to a person whose whose rights have been violated under the trademarks law. We also proceeded to draft relevant documents, and these documents we had, one was application for trademark registration, notice of objection, trademark registration. We also looked at concurrent use under section 27, where the registrar has accepted that it's in good faith that trademark can be used concurrently. And of course, we have the case of Kenya Javas versus the Cafe Javas of Uganda, where Christopher Madrama stated that the trademark was capable of concurrent use. We also looked at what we call permitted use, and when we talk about permitted use, basically mean that the owner of the trademark has permitted you to use that trademark. So here we must have a licensing agreement which basically permits you to use that trademark. So there is also assignment of trademark arises where the person sells that trademark to you. Then we call that assignment, the transfer of trademark from one person to another. That's what we basically called assignment. Then also looked at copyrights and neighboring rights, and these ones are covered by the Copyrights and Neighboring Act, and these accrue when a person has a neighboring rights. And neighboring rights could be rights of performing artists, broadcasting rights. Basically, when we talk about the neighboring rights, those are the rights which accrue for third parties, not the original creators of work. So for example, if you have authored a book and I come in as a distributor, that basically means I have neighboring rights. For example, now DSTV has neighboring rights for English Premier League. Basically, that's what we call neighboring rights. That these are third parties who have come up to also get rights, but they are not the original creators of the work. Then also looked from there, we looked at registration of a copyright, and basically how do you register a copyright. You have to apply to the registrar, and if that one is not registered, then the registrar can continue to register that copyright. Neighboring rights contracts, where we drafted licensing agreements between DSTV and of course I think and the English Premier League, YouTube, I think, and Kenzo, but all those ones are always called a licensing agreement. And basically here you are looking at the key clauses. We have copyright protection, term of the agreement, the geographical area of the agreement, terms and payment, warranties, among others. Then also looked at structuring business contracts. We looked at contracts of agency, and you have to understand that agency is covered by the Contracts Act, the principle of an agent, and a principle, basically agencies where you are acting on behalf of another, and you must act within that scope of authority. Remember that general rule that an agent cannot delegate, delegate. So it basically means we have a lot of duties of an agent. One, to report the principal. Two, you are entitled to remuneration. Three, you must act within your authority. Four, you must also not deal with competitors. So some of the duties which are always available to agents. But this agency relationship is always used by, for example, DSTVs, Zuku, always use the agent relationship. Then distributorship arises when there is a manufacturer and you want to just distribute those goods. For example, now it could be like Coca-Cola. If you want to distribute sodas, then now you are a distributor, and we sign under what we call the contract of distributorship. So one of the duties we have as a distributor, one is how to pass on market information to the manufacturer. Two, you must sell according to the agreed price by the manufacturer. Three, you have a specific territory you have to be working in. And four, you also always have a commission that the manufacturer must be paying you. Then also at franchise, the best way you can understand franchise is when you look at the KFC relationship. So franchise can either take a product, a service, or a business system. So franchise basically means that the person gives you his business system and you continue to go and operate the business system. So basically for a franchise, there you have the benefit of training, you have the benefit of market information, because basically you just get a system which is already working and you come and implement it here, so you don't have to invent the wheel. For example, what you can see in Cafe Javas, what you can see in KFC, basically those ones who are operating under a franchise. So basically here you have to sign what we call a franchise agreement, and in these agreements, basically we always have confidentiality, term of commencement. We also have territory. You have duties of the franchisor. You also have commission or terms of payment, and also termination of the franchise. So those are some of the key clauses, but you must think about confidentiality and trademarks, and basically how are you going to protect those things. Those becomes one of the key clauses you have to look at in case you are looking at those things. We also proceed to look at the contract of employment, and among here we looked at who is an employee, who is an employer, what's the contract of service, and what's the contract for services. We said an employer is a person who employs any other person. Then under the contract of services, contract of service, basically when you hire a person to as an independent contractor, is under the contract of services. Then we talk about contract for services, and under what circumstances do you establish that this is a contract of service or contract of services. So we looked at the different situations. One, the control test, the multiple test, and the integration test. When we talk about the multiple test, you are looking at whether this person is the tools is owned by the worker, and also the level of control to be able to identify whether he's an independent contractor or maybe if he's an employee. We also looked at casual workers. We say that these casual workers, they always are entitled to daily payment, and they must not be work for casual workers beyond 4 months. We also looked at migrant workers, and under what situation do you employ a migrant worker, because first and foremost you must apply for the work permit from the immigration office, and you must prove that there is no Ugandan who is capable of doing that work. You attach the passport, you attach academic qualification of that person, and then if the immigration office are satisfied, they will give you what we call a work permit. We also looked at labor unions under Article, of course, Article 29, freedom of association, and how do you the right of employees to form their labor unions. How can you register a labor union? Of course, you have to attach the members of the labor union, and you proceed to apply that you be registered as a trade union. So there is a right for every worker to join a trade union, which cannot be violated by the employer. So we also looked at basically the trade unions. How do you form one, and how do you join one? But it's a constitutional right for a person to form a trade union and also to be in position to join a trade union. So basically that was it, what we looked under the employment week, whereby we also looked at drafting an employment contract with key clauses like terms of payment, duration of work, termination of the employment, confidentiality, among others. Those were some of the key clauses we looked on the employment contract. Then from there we looked at sale of goods and supply of services, which is basically governed by the Sale of Goods and Supply of Services Act. So when we talk about Sale of Goods and Supply of Services Act, what we meant here was these goods must be Sale of Goods and Supply of Services Act. When we talk about sale of goods, we mean how basically what are the terms implied in this sale of goods contract. For example, look at title. There must be good title. Secondly, if it's sell by description, it must match the description. Sell by sample, it must match the sample. Then also look at that you must ensure that you are passing over good title to this person. So those are some of the implied terms which are implied in this sale of goods contract by the Sale of Goods and Supply of Services Act. So we looked at one, title. We also looked at sale by sample, sale by description, among others. Also, you have to understand the difference between a condition and a warrant. because the condition is something which is very essential to the sale of goods contract, that the breach of it, the contract can be repudiated. Whereas for a warrant, the breach of a warrant, and the person will only be entitled to damages. So we also drafted the standard form of sale of goods contract, whereby we also have a sales agreement of a car, among others. So those are some of the things we looked at in sale of goods, and at what point does property pass, and the rules governing the passing of property in the sale of goods contract. So when we basically talk about passing of property, we mean risk and ownership, because according to the Sale of Goods Act, Section 27, risk passes with property. And it's very, very important to understand at what point does property pass, because there we shall be in position to understand who basically has the risk of that product. We also looked at construction of contracts. Basically here we discussed construction of services. How can you reduce risks in a construction of contract by basically getting insurance. I also looked at making a service level agreement, and a service level agreement basically looks at the expectations of the contractor and also the service provider in that service level agreement. We also looked at the human resource recruitment agreement, which is also what we call the outsourcing agreement, where a company wants to hire workers but it doesn't want to directly hire these workers, where we drafted the human resource recruitment agreement. So I think basically those were some of the things we had to look at as far as contract is concerned. What is important for you to understand is any question about contract, you can use your general knowledge of understanding construction. For example, what are the risks involved on construction, including loss of machinery, including accidents, and basically how do you protect those things? By ensuring that the workers are wearing helmets, by also getting insurance, a comprehensive construction insurance, and also how do you ensure that the payments are made in time and the construction is finished within the required period of time, and also you get quality work. This is where we looked at a performance guarantee by the bank, whereby LDC had to go into the bank and get a guarantee from the constructor that in case there are any mistakes, then the bank is going to pay. So lastly, we looked at insurance, and insurance basically, remember, it's a unique contract with the utmost good faith, and also payment of premium and indemnity. So once you have a contract of insurance, that means in case of an occurring of a loss, you can be indemnified. So basically what you have to understand is what is indemnity and also what is subrogation. So when we talk about indemnity, it means if a person has suffered loss, you are able to be compensated for the loss you have covered, as long as it was in the scope of other insurance coverage. But second, you have to also understand the doctrine of subrogation, that if the insurance company has paid you and it was a bus company that caused you the loss, the insurance company can go after the bus company to recover the money they paid you. So basically that was it, how we looked at corporate. We also looked at risk management, and you can only manage risk, of course, through insurance, and also making sure that you make proper due diligence to get the best service providers. So that's why we are also very important in making sure that we make due diligence of this service provider to make sure that we get the best service providers. So basically that's what we looked at as far as corporate and commercial is concerned. You have to make sure that you understand these things in an easy way. Then if you can later put sections to them, or maybe cases, but it's not really hard. And I also wish you success in your oral exams. But in case you want a mentorship program, or maybe something to help you in your oral preparation, or maybe in answering the final exams, you can join us. We have a mastermind program where students pay a monthly subscription fee, and you can be able to access a very dedicated service and also support. And we only operate online, so we are in all campuses: Mbare, Kampala, and also Lira and Mbarara. So please, I wish you the best oral exams. You are not the first one to do oral exams, and neither will you be the last. So please don't be fearful, have faith, and once you have faith, then everything is going to become easier for you. I really wish you a blessed week and happy oros.